All right, I'm at the video upload. All right, this is Trump and the G, the Stock Exchange, of course, and this is Judge McAfee refuses to dismiss Trump charges under First Amendment. Like I've said in the previous show, the Trump's defense attorney, led by superstar lawyer Steve Sadow, tried to dismiss the case under First Amendment rights, saying that Trump's speech, the actual RICO charges for election interference down in Georgia, he tried to dismiss the case under First Amendment rights, saying that the president's speech was protected speech under the First Amendment. And even though a grand jury had seen the evidence and decided otherwise, they tried to dismiss the case. And the ruling from Judge McAfee just came out. He said, this is from the Hill, article from the Hill. It says, Georgia judge refuses to toss Trump's charges under First Amendment. Okay, this is what he says, what the Hill says, even core political speech addressing matters of public concern is not impenetrable from prosecution if allegedly used to further criminal activity. So here's the rub. That they're saying that the defense attorney is saying it's free speech. The state and Fannie Willis, DA, Fannie Willis said that the intent was to overturn an election, which is criminal. So I have the 14-page brief from the court from Judge McAfee, and it says, let me give you the broad point. It says, the defense said they argue this prosecution violates the First Amendment's protections of political speech and activity, freedom of association, and the right to petition Congress as applied to their alleged conduct. It says the argument of counsel and the indictment, the court finds these vital constitutional protections do not reach the actions and statements alleged by the state, nor do the statutes themselves facially violate the First Amendment. The defendant's motions are therefore denied. Okay. It also says on describing the First Amendment, it says, although the First Amendment is a broad umbrella that shelters all political points of view and shields a wide range of avenues of expression, free speech, including political speech, is not without restriction. Several narrowly defined forms of expression are categorically excluded from protection. When such a categorical restriction applies, levels of scrutiny have to have no analytical impact. And these excluded categories include speech integral to criminal conduct, fraud, or speech presenting an imminent threat that the government can prevent. I'll say it one more time. These excluded categories, as far as concerns free speech, include speech integral to criminal conduct, fraud, or speech presenting an imminent threat that the government can prevent. Right? It goes on to say, but like political speech, the right of association is not immune from restriction, particularly where the state indisputably has a compelling interest in preserving the integrity of its election process, and thus laws burden the associational rights of political parties and their members may be valid. It says, the protection afforded by a petition clause of the First Amendment, ensuring the ability to communicate will to government officials and regarded as implicit in the very idea of government, Republican informed, does not extend to allegedly fraudulent petitions. So the right to petition does not extend to fraudulent petitions. In other words, the law does not insulate speech allegedly made during fraudulent or criminal conduct from prosecution under the guise of petitioning the government. The right to petition is not absolute, nor does it carry special First Amendment status that would render claims asserted under it immune from criminal recourse. All right. The court also says the indictment alleges that defendants Giuliani, Smith, Shealy knowingly and willfully made false statements to members of the Georgia Senate at a Senate Judiciary Subcommittee meeting, that the defendants knowingly and willingly made and used a false document and conspired to knowingly and willfully file false documents purporting to certify 2020 presidential votes of the electors from Georgia, and falsely representing that defendants were chairman and secretary of the 2020 Georgia Electoral College meeting, that the defendants mailed with the intent to file a false certificate of the votes of the 2020 electors from Georgia in a court of the United States and conspired to knowingly file enter, and record the false document. The defendants Trump and Eastman knowingly filed a document containing false statements concerning the election in a lawsuit in the United States District Court for the Northern District of Georgia. So the defendants conspired to commit a solicitation of false statements and writings involving an election worker, and that defendant Schaefer knowingly and willfully made false statements in the presence of Fulton County District Attorney's Office investigators. So those are kind of statements of fact. Either they did or they didn't. This is what the state's saying. Either they did or they didn't. That's up for the jury to decide. Apparently, the court says after interpreting the indictment's language liberally in favor of the state as required at this pretrial stage, the court found that the defendant's expressions in speech are alleged to have been made in furtherance of criminal activity and constitute false statements knowingly and willfully made in matters within a government agency's jurisdiction which threaten to deceive and harm the government. So it says, after interpreting the indictment's language liberally in favor of the state as required at this pre-trial stage, so they're interpreting what the plaintiffs were saying liberally, and giving them the benefit of the doubt. The court found that the defendant's expressions in speech are alleged to have been made in furtherance of criminal activity. All right. It says, during an oral argument, the defendants posited that the speech at issue, even if false, was political and that one cannot be prosecuted for falsity alone. However, unlike the statute at issue in Alvarez case, the state's allegations do not suggest that this prosecution comes solely because it believes the speech was inaccurate, and the prosecution does not result in merely restricting false speech. Instead, the indictment avers throughout that the defendants acted willfully and knowingly, right? And that they impacted matters of governmental concern. These are not legal conclusions, but issues of fact. Accepting the allegations is true for the purposes of this pretrial challenge, as the court must. The speech alleged in this indictment is integral to criminal conduct and categorically excluded from First Amendment protection. It says the defense has not presented, nor is the court able to find any authority that the speech and conduct alleged is protected political speech. Although the defendants characterized their relevant speech or actions as petitions to Congress regarding the validity of electors which must be afforded constitutional protection, at this stage the court must consider the method and manner of the criminal enterprise as alleged in the indictment. And so the intent, whether it was criminal intent or intent to overturn an election, the best people to decide that are members of the jury, just like the defense said, just like the state said. Just like the state said in its indictment that what President Trump's intent was, or his members of his allegedly criminal enterprise, what their intent was, is best decided by a jury. And that seems what's going to happen. So looks like we're going to court down in Georgia. So there's all eyes on this case, and it seems to be the judge is backing up what DA Fannie Willis and the state saying, and this seems to be what people were saying all along, that of all the cases against Trump, this case may have the most legs in terms of the actual fact pattern behind what was alleged and the actual conduct. So that's Trump and the G. Thank you for listening. Thank you.